All right, well, thank you everybody for joining. I think we'll make a start. I'd like to welcome everyone to the fourth in our series of 6 regular arbitration breakfast briefings, which are taking place during the course of this year and which we hope you're going to find instructive. As usual, we say good morning to our friends and colleagues in the UK and elsewhere in Europe. Good afternoon, those joining from the UAE, Africa and Mauritius. Good evening to those in Singapore, elsewhere in the Asia Pacific region. A particular good morning to those joining from the Caribbean who've got up exceptionally early to listen to this. With me today are my colleagues James Walmsley and Bobby Friedman, who form part of the arbitration team at Wilberforce Chambers. Today's briefing, as you know, is concerned with anti-arbitration injunctions, and I stress anti-arbitration injunctions. As the name suggests, these are injunctions which seek to restrain the start or pursuit of arbitrations. We're very keen, as always, that this should be an exchange of views. We welcome your contributions, so please use the Q&A button at the bottom of your screens rather than the chat function to ask any questions through the session. We're very happy to try to deal with questions as we go along, so feel free not to wait until the end of the discussion if you have anything you'd like to raise with us. For light entertainment, as usual, we've got a few polls during the course of the discussion from which we're interested to get your own instinctive views on the questions we're going to ask. Now, it's all too easy to group anti-arbitration injunctions together with anti-suit injunctions which seek to restrain the start or pursuit of court proceedings. There are, of course, similarities between the two types of injunction. Courts, and less frequently arbitration tribunals, may grant both types of injunction, but there are also important differences between the two types. There's also a tension between the courts and arbitral tribunals concerning the use of anti-arbitration injunctions. This can be seen on the one hand as an unwarranted interference by the courts in the arbitral process, but on the other hand, a legitimate exercise by the courts to prevent abusive deployment of the arbitral process. So, in today's talk, we're going to consider from the English law perspective when and in what circumstances the grant of an anti-suit injunction may arise. We're then going to look briefly at the position in some other common law jurisdictions in the Asia Pacific region and also Canada, and finally mention some other discrete aspects of anti-arbitration injunctions with particular reference to recent case law. So, when may the question of the grant of an anti-arbitration injunction arise? Kicking off with that question, anti-arbitration injunctions may be granted as part of the court's role as the supervisory court of the seat of the arbitration. For example, under Section 72 of the English Arbitration Act 1996, the English court is empowered to grant an anti-arbitration injunction where there's no valid arbitration agreement, or where the tribunal hasn't been properly constituted, or where the matters submitted to arbitration fall outside the arbitration agreement. It's noteworthy that in practice, Section 72 has rarely been invoked. The English courts have taken the view that tribunals should generally be left to determine their own jurisdiction under the competence principle enshrined in the rules of all the major arbitral institutions, and that the court should exercise great caution before granting relief under Section 72. More commonly, anti-arbitration injunctions may be granted on grounds which involve no exercise of the court's supervisory role at all. And these grounds broadly cover two situations. First, where it's alleged that pursuit of the arbitration itself involves breach of some enforceable private law obligation, such as the choice of jurisdiction clause or some different arbitration clause. And second, where there's no such arguable breach, but where what is under consideration is, for example, the court granting an injunction in order to vindicate the integrity of its own process. That raises different considerations. In those situations, the English court has relied on Section 37 of the Senior Courts Act 1981, which empowers the court to grant an injunction in all cases in which it appears to the court to be just to do so. Section 37 has been relied on in relation both to arbitration seated in England, where Section 72 of the 1996 Act doesn't apply, and also to foreign arbitrations. There's a paradox in practice in that the English court, at least historically, has been less restrained in exercising its power under Section 37 in relation to foreign arbitrations, bearing in mind that the court would be interfering in both the foreign arbitration proceedings themselves and the powers of the foreign supervisory court. So what we're going to do today is to look first at the position with regard to English-seated arbitrations, then with the position with regard to foreign-seated arbitrations. And the approaches differ, and one may question whether those differences are in fact justified.
Good morning, everyone. So turning first to English-seated arbitrations, there's no doubt that an English court may grant an anti-arbitration injunction in relation to an English-seated arbitration. As Stuart has mentioned, the court has the power to do so under Section 72 of the 96 Act and under Section 37 of the Senior Courts Act 1981. Examples of that jurisdiction being exercised are, however, relatively rare. Now here we do want to acknowledge a very erudite discussion by Professor Garnis of the University of Melbourne Law School in an article published last year in Arbitration International, which we've considered in coming to our views, although, as we will explain, they do differ somewhat from Professor Garnis on a number of the points in question. Now, the reason for the fact that it's relatively rare is that the jurisdiction may only be exercised in exceptional circumstances. To make good such circumstances, the applicant will need to demonstrate A, that the injunction does not cause injustice to the claimant in the arbitration, and B, that the continuance of the arbitration would be oppressive, vexatious, unconscionable, or an abuse of process. In J. Jarvis and Sons against Blue Circle Dartford Estates, the court referred to this test, that's paragraph 40 of the judgment, and stated that the discretion should be exercised only very sparingly. So while it's under the Senior Courts Act that the court has jurisdiction, unless Section 72 of the 1996 Act is being relied on, it's necessary for the discretion to be exercised in accordance with the scheme of the 1996 Act generally. And it's for this reason that case law predating the 96 Act should be treated with caution. Jarvis itself said that the exercise of the jurisdiction would be even more sparing following the introduction of the 1996 Act. So now it's necessary to show not just that the Section 37 jurisdiction can be invoked, but also that granting the anti-arbitration injunction would be consistent with the statutory scheme under the 1996 Act. So, for example, that proposition is made good in Electrum and Vivendi Universal at paragraph 53. Well, what are the consequences of this? One is the lack of relevance of what might be called simple case management grounds, such as an overlap of subject matter or inconvenience or waste of costs. Now, as we all know, one part of the statutory scheme is Section 9, providing for the stay of court proceedings in favour of arbitration. It's now well established that the right to a stay arises only in respect of those parties and claims that are subject to the arbitration agreement. So, for example, if the agreement covers only a contractual claim, the tortious claim will not be subject to a stay. Likewise, where there's a non-party to the arbitration agreement, that party would also not be covered. For example, on that point, there's the well-known case of Deutsche Bank and Tonka Harbour Public Company. So it follows from Section 9 that it is to be expected that there will be some undesirable case management outcomes with an overlap of subject matter or parties. The mere fact, therefore, that the existence of arbitral proceedings will cause such outcomes does not make them vexatious or undesirable per se. Importantly, therefore, a multitude or a concurrence of proceedings will not by itself lead to vexation and would not be sufficient to justify an anti-arbitration injunction. An example of this can be seen in Electrum and Vivendi, the case I mentioned a moment ago, where an attempt was made to injunct an LCIA arbitration pending the completion of an ICC arbitration seated in Geneva. The LCIA arbitration was started against Electrum and 2 other companies. The ICC arbitration was brought against Electrum and 8 other companies. Now, the court assumed for these purposes that there was a legal right on the part of electrum to have the arbitration carried out in accordance with the principles of Section 33 of the 1996 Act, including, therefore, that the tribunal should adopt procedures that avoid unnecessary delay or expense. But even so, the court considered that it was not appropriate to grant an injunction. The court emphasised that it has no supervisory role in advance of an award of the kind that it was being asked, in effect, to exercise in that case. It referred, in fact, to Section 1C of the 1996 Act, which provides that in matters governed by this part, the court should not intervene except as provided by this part. This was said to be an express statutory warning. Now that stands in contrast, for example, to the extent of a tribunal's powers under Section 30 to rule on its own jurisdiction. It should not therefore be assumed that the court is able to or will intervene merely on the basis that something must be done. On the contrary, there is no wider residual jurisdiction. The court does not, for example, step in to consolidate various arbitrations that might more conveniently be case managed together. Indeed, if there is a breach of Section 33, the 96 Act sets out the procedure that should be followed to deal with the consequences of that breach. Now, this must be the only right conclusion, given that the statutory scheme is not imposed. Rather, that scheme is one that the parties have signed up to in agreeing to an English arbitration. And there's a well-known exposition of that point in the case of C and D in the judgment of Mr. Justice Cook. He said that as a matter of construction of the policy and the arbitration provision with it, with its express reference to English law and the 1996 Arbitration Act, I consider that the parties have incorporated the framework of that Act and agreed that it should apply to any arbitration between them with all its mandatory provisions and with its non-mandatory provisions, save to the extent that there is agreement to the contrary. So for the same reasons, in considering whether or not the test for an anti-arbitration injunction is made out, the court will look at the rules of the arbitral tribunal in question. If, for example, the parties have agreed to an LCIA arbitration, they have agreed that the LCIA rules will apply. The broader consequence is that the court will generally leave the decision to the arbitral tribunal where it falls within the competence of the tribunal. An example of that can be seen in nominal securities and mobile telesystems finance, where there was, it was said, a collateral attack on an earlier award through re-arbitration. The court emphasised that under the LCIA rules and the application of competence, the tribunal could determine whether a collateral attack was in fact being made by the bringing of the second arbitration, so that it would not be vexatious to allow that second arbitration to continue. If there was in fact an abuse of process, the arbitral tribunal would strike out that second arbitration.
So when might the necessary exceptional circumstances to which Bobby has referred be made out? The answer to that question is to look back to the scheme of the 1996 Act. Many of the examples where the court has been willing to grant an injunction have come where the arbitration is itself seeking to subvert that scheme, or where the arbitration is vexatious because it seeks to deal with points that have already been determined by the supervisory court. A good example comes from the 2019 Court of Appeal decision, Minister of Finance Inc. and 1MDB and International Petroleum International Company, Investment Company. In that case, a deed had settled a London arbitration and provided for a consent award. Pursuant to the deed, any dispute arising from or in connection with the deed was referred to arbitration. The claimant sought to set aside the consent award under Section 67 and 68 on the basis that the tribunal lacked substantive jurisdiction for lack of authority, and also on the basis the consent award was procured by fraud. The defendants commenced, in response, a second arbitration, claiming events of default under the settlement deed, entitling them to payment. The events of default were said to include the court challenge under Sections 67 and 68 of the 96 Act. The claimant sought and, on appeal, was awarded an anti-arbitration injunction. The court's reasoning was the flip side of the reasoning as to why, as Bobby has explained, an injunction will not be granted where to grant an injunction would subvert the scheme of the 96 Act. In this case, the court focused on the fact that there were mandatory provisions, that is sections 67 and 68, put in place not merely for the parties, but also in the public interest. So the court granted an injunction to ensure that those provisions were effective. The court emphasised that sections 67 and 68 reinforced the rights of the parties and protected the integrity of the court process itself as well as the legal process more generally. The second arbitration was based on a contractual scheme that sought to fetter the exercise of a statutory right to have the court review the first award, and that made it vexatious. The court made clear that where the proceedings were no longer consensual, the election to arbitrate could no longer dictate the procedures. Moreover, the court, exercising its supervisory role under the 96 Act, is acting as a branch of the state, not as a mere extension of the consensual arbitration process. It would therefore not be right to leave matters to the tribunal in the new arbitration. In a similar vein, where the English court decided in a different case that a party was not a party to an arbitration agreement, it was appropriate to grant an anti-arbitration injunction to stop the claimant from reconvening the arbitration proceedings. The tribunal had no jurisdiction, and that was a point that had already been decided by the supervisory court. In other words, the tribunal must defer to a prior decision of the court. And that's the fact pattern of Republic of Kazakhstan and Istil Group, a 2007 decision. So much for when the exceptional circumstances are made out. Ultimately, though, of course, as the matter is discretionary, even where those circumstances are made out, the court will take into account all of the circumstances before granting an injunction. Each case will therefore turn on its own facts. So, for example, in the case of Electrim, to which Bobby's already referred, the tribunal had itself already refused to stay its own proceedings. This was at least part of the court's overall decision in refusing the injunction. One specific consideration will be delay. It'll be an important factor in the exercise of the court's discretion, even though in many cases the position concerning delay appears to have been used to reinforce a decision reached on other substantive grounds. The approach has been strict. For example, in the Jarvis case, it was enough that the arbitration had been on foot for many months and that the application to court was made only 2 weeks before the arbitral hearing. In short, care should be taken to bring an application for an anti-arbitration injunction as speedily as possible, but we shall come back to delay after first discussing the position in respect of foreign-seated arbitrations.
So let me introduce the subject of foreign-seated arbitrations. I noted when introducing this talk that there'd been a paradoxical history in that certain English cases that in the past suggested that maybe the English court would be persuaded to interfere with foreign-seated arbitrations by reasoning that would not be consistent with the approach that's just been outlined for English-seated arbitrations. Professor Garnett's paper, to which Bobby has referred, provides an interesting analysis in that regard. But rather than go through that history, I want to focus on the English Court of Appeal's decision in a case called Sabbagh and Khoury a few years ago, which is of prime importance. Although the decision is almost 2 years old, it's yet to be subjected to very detailed or extensive analysis in commentary, so far as we're aware. The case involved anti-arbitration injunctions relating to a Lebanese-seated arbitration. We'll outline the facts of the case and go into it in a bit more detail presently. But to set out in advance the key reasoning why this case is of some interest before you hear from James and Bobby, they are these. First of all, the case is significant because the appellants launched a full frontal attack on the jurisdiction of the English court to grant any injunction at all in respect of foreign-seated arbitrations, at least in the absence of some relevant breach of a private law right. The court rejected the arguments raised but did appear to accept that the court should exercise great caution and restraint before granting an injunction in respect of a foreign-seated arbitration in particular. We're going to look at that analysis and explore the question of why foreign-seated arbitrations should be seated differently at all, once one is concerned with a question of vindicating the integrity of the court's own process. The second point, and a point which the appellant sought to argue by analogy with the test in the context of anti-suit injunctions, founded on vexation or oppression, that there was a requirement that the English court be the natural forum for the proceedings putatively to be protected by the injunction before such an injunction could be awarded. The court rejected that argument, which is important in itself, but it also serves as an important illustration of the different considerations that apply in the context of anti-arbitration as opposed to anti-suit injunctions. Finally, the case is informative because there were actually two anti-arbitration injunctions under consideration, and the end result was that one was upheld and one was discharged. So one can see that exploring why they felt to be treated so differently might assist in unpacking what approach the court will take to anti-arbitration injunctions in practice. Each one of the two acts as a compare and contrast with the other. We'll therefore look in a little detail at what can be extracted about the legal test to be applied. And the conclusion will be that one should be very cautious indeed about being drawn into extracting any bright line threshold tests or procedural conclusions from the decision. It's very tempting to say that the decision stands for some bright line test, but on analysis, our view is that that is not the case.
The facts of Sabbagh are complex, but I can attempt to summarize them relatively briefly for the purposes of today. English commercial court proceedings were commenced in July 2013. The claims in the proceedings related to a large Middle Eastern construction group co-founded by a Hasib Sabbagh, who had suffered a stroke in 2002 and died in 2010. The claimant was the daughter of Hasib, and the defendants included, among others, her brothers and cousins. There were two claims. First, the claimant claimed that the defendants had conspired to misappropriate assets belonging to her father, but held by the relevant Lebanese company during his lifetime, after he had suffered a stroke in 2002. That came to be known as the asset misappropriation claim for obvious reasons. Secondly, the claimant claimed that the defendants had conspired to deprive the claimant of her entitlement to shares held by Hasib on his death. That claim came to be known as the share deprivation claim, again for obvious reasons. The defendants brought numerous jurisdictional challenges in relation to those two claims, including applications for stays pursuant to Section 9 of the Arbitration Act 1996. All the jurisdictional challenges were ultimately dismissed by the Court of Appeal in 2017. Some of the defendants had also, back in 2014, commenced a Lebanese arbitration under an article of the constitution of the relevant Lebanese company. Those defendants, who were for obvious reasons referred to as the arbitration claimants, pursued in the arbitration claims that were clearly intended to operate or purport to operate as mirror images of the English court claims. Thus, there was an assets claim focused on an alleged shareholder account held by Hasib, which plainly was intended to mirror the asset misappropriation claim, and also a shares claim focused on the question of whether Hasib indeed still held any shares in the company on his death, and that was clearly intended to mirror the share deprivation claim. The claimant in the court proceedings, the daughter, did not participate in the arbitration. Following the Court of Appeal's rejection of the jurisdiction challenges in 2017, including the Section 9 stay application, the following year, the claimant obtained an anti-arbitration injunction from the English court restraining continuation of the Lebanese arbitration, both in relation to the assets claim and the shares claim. Mr. Justice Robin Knowles was satisfied that it was vexatious and oppressive for the arbitration claimants to continue to pursue that Lebanese arbitration in the face of the decision and reasoning of the Court of Appeal and in particular the dismissal of the Section 9 state applications. The judge was satisfied that it followed from the July 2017 decision of the Court of Appeal that the Lebanese Arbitration Tribunal had no jurisdiction. The clear purpose of the arbitration was to obtain an award against the claimant, which they would try to enforce or have recognized against her, which would produce uncertainty for the enforcement of any judgment in her favor in the English court proceedings. That granting of the anti-arbitration injunction was then appealed, and the end result of the appeal in the Court of Appeal's 2019 decision was that the anti-arbitration injunction in relation to the shares claim was discharged, but the anti-arbitration injunction in relation to the assets claim was upheld.
Much of the judgment of the Court of Appeal, paragraphs 50 to 91, and therefore 42 paragraphs of the 115 paragraph decision, is devoted to the first point that the appellants took, namely that the English court had no jurisdiction at all to grant an anti-arbitration injunction in relation to a foreign-seated arbitration, on grounds that it would be vexatious or oppressive because of proceedings in this jurisdiction, rather than on grounds of vindication of some private law right, for example, under a contractual jurisdiction clause. The main argument raised in this context was that a jurisdiction to restrain foreign-seated arbitrations for vexation or oppression was fundamentally inconsistent with the scheme of the 1996 Act and the New York Convention. The court rejected that argument for the following reasons. First, the starting point was Section 37 of the Senior Courts Act, as we've discussed. It's well established that under this provision, the court has power to grant injunctions restraining proceedings in foreign courts, where by reason of parallel proceedings in the English courts, such foreign proceedings are vexatious and oppressive. The Court of Appeal was satisfied that a similar power must exist as regards foreign arbitrations, unless by statute the scope of Section 37 had been implicitly modified. And then the court went on to consider whether the 1996 Act, construed against the background of the New York Convention, contained anything that performs such an implicit modification. It concluded that it did not. However, in the course of its reasoning, it's notable that the court appeared to accept that anti-arbitration injunctions against foreign-seated arbitrations are a special case. Thus, the court cited with approval, see paragraph 86, the remarks of Mr. Justice Hamblin, as he then was in the earlier case of Claxon Engineering, to the effect that the need for caution in the granting of anti-arbitration injunctions was all the greater where the seat was foreign, because such matters are generally best left to the relevant supervisory courts of the country of the seat of the arbitration. Though finding in favour of the claimant on the point of jurisdiction, the court did conclude at paragraph 90 that the claimant could derive little or no support from those cases where the court has restrained an English-seated arbitration, because in such cases the English court is the supervisory court. But where the focus is on vindicating the interest of the court's own process and avoiding the vexation or oppression caused by parallel proceedings, and the court is not purporting to exercise any form of supervisory jurisdiction as such, what is the rationale for being more cautious in respect of a foreign seat arbitration than with a domestic arbitration? There is a fundamental principle of international arbitration that the courts should uphold and not interfere with arbitration agreements. But that fundamental principle does not distinguish between arbitrations which happen to have a seat that coincides with the jurisdiction of the court and those that do not. Though it is a theme of the authorities, including Sabbagh, that there is to be extra caution in cases involving foreign seats, that logic seems to us to be full of holes. It would not, after all, make sense to go to the foreign supervisory court and say, this arbitration is vexatious and oppressive of certain foreign court proceedings, so please restrain it. That question is not one that arises within the world of arbitration supervision. It may be that on the facts of a given case, the argument for vexation or oppression itself requires going into a matter that is paradigmatically for the supervisory court rather than some other court. An example might be an issue over the jurisdiction of the arbitrators in relation to the dispute in question. Where that is the case, one should no doubt then ask whether there is a means of addressing the concern which involves resolving the issue through applications to the supervisory court. But such an analysis depends on the facts of the particular case. And even where the underlying concern is one of jurisdiction, there may be good reasons on the facts of a given case why the English court should want to step in at that point. For example, because under the law of the seat, there is no application that can be made to the supervisory court at that particular stage of the arbitration. And this theme is picked up in the next point, which is concerned with whether a precondition for the grant of an anti-arbitration injunction is that England is the natural forum. The Court of Appeal dealt quite shortly, at paragraphs 101 to 114, with the appellant's argument that by analogy with the test in the anti-suit context, the court can only award an anti-arbitration injunction for vexation and oppression if it is the natural forum for the claim pursued in the proceedings that it is seeking to protect. The appellant's argument was that since that was a requirement in the anti-suit context, it should apply equally in the anti-arbitration context. The court examined the rationale behind the principle in the anti-suit context. It identified that it came down to comity. The court then identified that the rationale did not apply in the context of arbitrations. It said that the rationale does not apply to a foreign arbitration. An anti-arbitration injunction does not involve an interference with the jurisdiction of a foreign court, except in the very indirect way of relieving it of its role as a supervisory court for the arbitration. But that is a role that is entirely dependent on the continuation of the arbitration. Since there was no serious concern for comity, there was no requirement for a natural forum precondition. There is a real logic here, though one might wonder how it ties in with the idea that somehow there needs to be extra caution in relation to a foreign-seated arbitration. It is true, though, that some of the other reasoning of the court in this context appears to assume that the court will only grant an anti-arbitration injunction where it has concluded that the arbitral tribunal lacks jurisdiction. That is an assumption that requires some scrutiny. We do that now by looking at the discharge of the shares claim anti-arbitration injunction.
It'll be remembered from the introduction given earlier that there were two anti-arbitration injunctions in the Sabbagh case, and that one of them, the one in relation to the shares claim, was discharged. But the consequence of that discharge was not that the share deprivation claim in the English court proceedings fell away. It'll be remembered from the earlier summary that in 2017, the Court of Appeal had rejected the application for a Section 9 stay of that conspiracy claim in relation to the shares. So the result of the 2019 Court of Appeal decision was that the parties were faced with both the English court conspiracy claim and the Lebanese arbitration shares claim. How did the court find its way to that result? There were two basic steps to the reasoning. First, the court accepted the principle that the court cannot grant an anti-arbitration injunction in relation to a claim that, if pursued in court proceedings, would be bound to be stayed under Section 9 of the 96 Act. Second, the court accepted the argument that the shares claim, as pursued in the Lebanese arbitration, had not been found in the 2017 decision to be outside the relevant arbitration agreement, and indeed concluded that it was within the arbitration agreement. As to that first step, though, the question is, why should there be a threshold test in relation to the granting of an anti-arbitration injunction that depends on the answer to a hypothetical question about a claim that's not being brought in court proceedings, and indeed a hypothetical question about an application for a stay under Section 9 that may or may not have been made if such hypothetical court claim had in fact been brought? The answer is said by the Court of Appeal to be that to award an anti-arbitration injunction in respect of an arbitration where the relevant claim would have been stayed if pursued in court proceedings would be, quote, wholly contrary to the fundamental principle underpinning the New York Convention and the 96 Act of respecting and giving effect to arbitration agreements. But what respectfully we think is missing there is an explanation for why it would be wrong for that fundamental principle to be subject to a qualification where the arbitration is pursued with a vexatious or oppressive purpose. One can test it this way. Suppose that an arbitration was commenced in the run-up to a court trial with the obvious intention to disrupt preparation for the court trial and also potentially to disrupt enforcement of any judgment arising out of that trial. Suppose that the matter was within the scope of the arbitration agreement, such that if counterfactually a court claim had been brought in relation to that matter, then a stay would have been mandatory. Would it be impossible in those circumstances for the court to protect its own process by awarding an injunction? On the particular facts of Sabbagh, testing the matter by reference to a hypothetical Section 9 application in a hypothetical court claim might be argued to have led the court into a further mistake. For the position on the actual facts of the case is that though the English court's share deprivation claim was a claim in conspiracy, the Court of Appeal had in the 2017 decision implicitly decided that the English proceedings did not need to be stayed by virtue of the issues on the shares claim. Otherwise, it would have granted a stay, or at least a partial one, to the extent of the issues in the court claim that failed to be arbitrated. That follows from the principle that where there is an arbitrable issue in court proceedings, the court is obliged to stay the English proceedings to the extent of that issue. That's the analysis of the basic principles to be applied in respect of Section 9 set out by Mr. Justice Popplewell in the case of, unpronounceable case, I should say, of Sostovitsny and Ruhan, 2018. What the Court of Appeal in its 2019 decision failed, therefore, to take properly into account, it may respectfully be submitted, is that the arbitrability of the shares claim was inconsistent with the refusal to award any stay in 2017, such that maintaining the anti-arbitration injunction should be refused amounted to a collateral attack on the earlier 2017 decision. Now, there may be a question as to whether the situation is best analysed as involving the parties being precluded as a result of the 2017 decision from asserting the arbitrability of the shares claim, or better analysed as simply supporting the conclusion that the pursuit of the shares claim arbitration is vexatious and oppressive, even if arbitrable. But one way or the other, the focus on a hypothetical Section 9 stay application in hypothetical court proceedings, rather than what the position was on the actual state of affairs, appears to have led to a mistake. Our view, therefore, is that one should be cautious about extracting from Sabbagh a bright line threshold test that requires consideration of a hypothetical Section 9 application.
So here we come to our first poll, the question which is coming up on the screen is this: was the Court of Appeal in Sabbagh right to discharge the shares claim anti-arbitration injunction? No prizes and limited relevance to what the answers of the poll may be, rather like TV adverts saying that 90 out of 100 people preferred this shampoo, but let's have your view. We've got the answers coming in. Just give it a moment. Well, a small majority in favour of the Court of Appeal in Sabbagh being wrong to discharge the shares claim anti-arbitration injunction. Thank you very much for that. Let's go on now and have a look at the assets claim anti-arbitration injunction.
So turning to the second part of the decision. In 2019, the Court of Appeal upheld the assets claim anti-arbitration injunction. The explanation of its position on this and its reconciliation with the discharge of the shares claim anti-arbitration injunction is set out at paragraphs 113. In short, the Court of Appeal regarded the assets claim anti-arbitration injunction as falling into the category of case where the English court has, for justifiable reason, made a previous determination to the effect that the relevant claim pursued in an arbitration is not within the scope of the relevant arbitration clause. In this case, it had made such previous determination in the context of dealing with the Section 9 stay application. Where the court has made such a previous determination, it can, on the Court of Appeal's logic, in principle, grant an anti-arbitration injunction. It's been suggested by at least one commentator that a consequence of this is that it is a necessary condition for getting an injunction that you have secured some previous determination, effectively for some reason entirely independent of pursuit of an injunction. If that is right, then it has some significant tactical consequences. For instance, a party faced with court proceedings who would rather have the matter dealt with through arbitration may in some circumstances be better off starting an arbitration with a view to obtaining recognition of an award from that arbitration and ignoring, in particular, the court proceedings altogether, on the basis that seeking a stay of the court proceedings runs a risk of generating a determination that becomes a previous determination for the purposes of a subsequent injunction application. However, that very example might suggest that there's something wrong with the logic, where the key litmus test is whether there has been a previous judicial determination of the arbitral tribunal's jurisdiction. It's a very odd legal mechanism to say that a court can only do something where it's previously determined that such and such is the case, where the matter must necessarily have only come before the court previously for reasons independent of the request that the court do that thing. It would follow, for example, that where a defendant does not participate at all in court proceedings, you could not seek an anti-arbitration injunction unless they are to be treated, notwithstanding the non-participation in the court proceedings and pursuit of an arbitration, to have agreed that the claim is not arbitrable.
So that takes us on to the second of our polls today. Should it be a precondition for the grant of an anti-arbitration injunction that there had been a prior judicial determination of the arbitral tribunal's jurisdiction? We're all being very critical of the Court of Appeal today, so see whether that continues or not. We've got the answers coming in, which we will see in a minute. A strong majority in support of the proposition that it should not be a precondition for the grant of an anti-arbitration injunction that there's been a prior judicial determination. Happy to say that's my view as well. I don't know which way Bobby and James voted. Thank you very much for that. So I want to move on now to cover some other areas. We've got about 20 minutes left. First, the position in other common law jurisdictions, which I mentioned earlier. We've been looking so far at the English law position in some detail. The position in other common law jurisdictions isn't uniform, although some common features can be identified. In Professor Garnett's paper, to which we've referred, he conducted a survey of the position in Hong Kong, Singapore, Malaysia, Australia, New Zealand, and Canada. And in summary, from the case law of those jurisdictions, one can see a general reluctance in the case of locally seated arbitrations to grant anti-arbitration injunctions unless third-party interests were involved. But in contrast, one can see a greater readiness to grant such relief and perhaps insufficient concern for the roles of the foreign arbitral tribunal and the foreign supervisory court. There seems to be some evidence of a Sabbagh type approach taking root, but it's patchy at the moment and it's applied in an inconsistent way. Moving on then to other discrete aspects of anti-arbitration injunctions which merit attention, I want to start with looking at the delay issue that James mentioned earlier we would be coming back to. In Sabbagh, one of the matters which did not have to be considered by the Court of Appeal was the question of delay and how delay was to be brought into the exercise of discretion in relation to an application for an anti-arbitration injunction. In the first instance, Mr. Justice Knowles had rejected the contention that there had been for relevant purposes delay, even though the arbitration had been commenced in 2014 and the application for an injunction was only launched in the second half of 2017. This aspect was very recently considered by the Commercial Court in England in two cases in the context of anti-suit injunctions. In Specialized Vessel Services and MOP Marine Nigeria, Mr. Justice Khoury, an extremely good judge, not least because he was my pupil, granted an anti-suit injunction despite there having been a significant delay in the application for it. In that case, in November 2019, the charterers of a vessel had started court proceedings in Nigeria against the vessel's owners for negative declarations that they were not liable in respect of a collision with a tugboat in Nigerian waters. A court in Nigeria granted an ex parte injunction preventing the owners of a vessel from pursuing a London arbitration against the charterer, which the owners had initiated in May 2020. And in January of this year, the owners successfully applied for an anti-suit injunction to restrain the pursuit by the charterers of the Nigerian court proceedings, which had been brought in breach of the London arbitration agreement in the charter party. The Commercial Court decided that despite the delay of over a year between the time the owners were served with the Nigerian court proceedings and the time they applied for the injunction, it would, in the exercise of its discretion, grant the injunction, because amongst other reasons, the Nigerian court proceedings hadn't progressed very far. Much of the delay had been caused by the Nigerian court process itself, and the charterers had not contested the validity of the London Arbitration Agreement. In the other case, Times Trading Corporation and National Bank of Fujairah, an injunction was granted notwithstanding a delay of 5 months before applying for an injunction to restrain the respondent from pursuing claims in the Singapore courts against the applicant on the ground of a London arbitration agreement. Now, what these cases show is that, first of all, delay is but one factor in the exercise of the court's discretion. Second, whether or not the delay is considered excessive, such as to lead to the refusal of the injunction, had to be viewed in the context of all the facts of the case. Third, interestingly and importantly in my view, the question of delay and judicial comity are linked, in the sense that the less the foreign court has been involved in the case during the period in question, the less will be the interference with the foreign court's process, which will result from the grant of the injunction. But fourth, against that, it should be borne in mind that the injunction is granted against the party to the foreign proceedings and not against the foreign court itself. It remains to be seen to what extent these considerations will apply across to anti-arbitration injunctions. In principle, they will, and support for that view is to be found in Mr. Justice Knowles's first instance judgment in Sabbagh. But judicial comity should, in our view, play less of a role where the injunction is sought to restrain foreign arbitration proceedings brought in breach of, say, a London exclusive jurisdiction clause. In practical terms, where an anti-suit or anti-arbitration injunction is sought, the obtaining of foreign law expert evidence relating to the delay should be considered. It played an important part in the Nigerian case to which I've referred.
Turning now to another of the last set of topics relating to anti-arbitration injunctions, the recognition of a judgment in proceedings brought in breach of an arbitration agreement. Section 32(1)(a) of the Civil Jurisdiction and Judgments Act 1982 provides that, subject to the other provisions of that section, a judgment given by a court of an overseas country in any proceedings shall not be recognised or enforced in the UK if the bringing of those proceedings in that court was contrary to an agreement under which the dispute in question was to be settled otherwise than by proceedings in the court of that country. The policy of the English courts, reflected in particular in the Arbitration Act 1996, is very pro-arbitration. Consistently with that, and pursuant to section 32(1)(a) that I've just read out, the courts will not give effect to foreign judgments obtained in proceedings brought in breach of an arbitration agreement. Hence, in Adactive Media Inc. and Ingruil 2021, a Court of Appeal decision from 2021, the court refused to recognise or enforce an order of a US federal court which awarded damages of $11 million in Californian proceedings, which were pursued in breach of an arbitration agreement which provided for arbitration in Los Angeles. The decision is particularly interesting because the seat of the arbitration under the arbitration agreement was not in England. Plainly, the fact that the defendant had not sought an injunction in California to restrain the court proceedings there was not regarded as a relevant consideration. Tangentially on this point, our February breakfast briefing looked at the Supreme Court's decision in Enker and Chubb on the choice of law governing an arbitration agreement. The Supreme Court was hearing an appeal from the Court of Appeal's decision to grant an anti-suit injunction to prevent the pursuit of a subrogation claim in Russia, which it was alleged was brought in breach of an arbitration agreement governed by English law. In confirming the availability of injunctive relief, the Supreme Court decided that it was irrelevant whether or not the arbitration agreement in question was governed by English or foreign law. The Adactive Media case is consistent with the thrust of that approach.
what about the role of the arbitral tribunal itself? So far, we've concentrated on the grant of an anti-arbitration injunction by the court, but the arbitral tribunal itself is also empowered under the 1996 Act to grant injunctive relief. In relation to anti-suit injunctions, the power has generally been sparingly exercised, but the power exists and has been exercised on a number of occasions of which we are aware, and probably on many more occasions of which we are not. So far as anti-arbitration injunctions are concerned, the situations in which an arbitral tribunal may be called upon to grant an injunction to restrain the pursuit of another arbitration are likely to be few and far between. Again, however, on rare occasions, that situation has arisen. For example, in one arbitration of which we are aware from our own experience, an ICC tribunal in a Hong Kong seated arbitration was called upon to grant an anti-arbitration injunction to restrain the respondent from pursuing another arbitration, which it had started against the claimant in Shanghai under SHIAC rules. The Shanghai arbitration had been initiated by the respondent following a unilateral variation of the original arbitration agreement, which purported to change the seat of the arbitration. Now, finally, when anti-arbitration injunctions are granted, the order will usually be made by the court against one of the parties to the arbitration proceedings. However, arbitral tribunals are not immune from themselves being injuncted from continuing with arbitration proceedings. It has been known that Indian and Sri Lankan courts in particular have granted anti-arbitration injunctions against the members of the tribunal personally. And this has caused potential difficulty for arbitrators wishing to travel to those jurisdictions, whether for the purposes of the arbitration, business more generally, or even for personal pleasure. In other jurisdictions, notably Singapore and Australia, there is authority against the grant of anti-arbitration injunctions against arbitrators personally. However, the cases in question concern domestic-seated arbitrations. From the viewpoint of authority, it does remain an open question whether the same situation would prevail in relation to a foreign-seated arbitration.
Well, ladies and gentlemen, that brings us a few minutes early to the end of today's talk on anti-arbitration injunctions. We hope, as always, that you found it useful. If there are any questions that you have arising out of today's talk, or you'd like the detailed citation of the cases to which we've been referring, feel free to email any of us directly. I'm conscious there's been quite a lot of references to case law during this month's briefing. As always, we welcome any thoughts and comments you may have and any suggestions for further briefings. Please leave your feedback on the post-webinar questionnaire that will come up on your browser after this session. It's also been recorded, and the recording will be available to you on the YouTube channel later this week in case you missed any of the session. If you want to find the channel, type Wilberforce Chambers in the YouTube search bar. And our previous breakfast briefings from the last 3 months are also available to view there. The Arbitration Breakfast Briefing Series 2021 continues next month. Next month's briefing, the 5th in the series, will deal with the impact of the UK's departure from the European Union for international commercial arbitration in the UK, both in its legal and practical aspects. We see Brexit as a blessing, not a curse, from a professional viewpoint, if not a personal viewpoint. The talk will take place at the end of May, and we look forward to seeing you again then. So please do keep an eye out for the invitation, which will come through over the next week.